Hello there. Let me firstly welcome you a good morning, a good afternoon, or a good evening on the basis of when you would be watching this video. In this video, we are going to discuss about marital rape as an issue and the very pertinent Chhattisgarh High Court judgment that has come up very recently, and there's a huge social media backlash that has surrounded or embroiled this entire controversy. I am Vaibhav Prakash, a National Law University Ranchi alumnus of 2016. Have been training students since my final year of law school, and by now have successfully trained more than 2000 plus students for various law entrance examination. And in this video, we are going to discuss this Chhattisgarh High Court judgment that has come up, where it has been held and said that sexual intercourse or any sexual act by husband with his legally wedded wife would not amount to rape even if it was done by force or against her wish. Now, ideally speaking, this is just the headline. Now, reading this headline would of course make anyone go or would allow anyone to think that what kind of a bizarre statement has been made by Chhattisgarh High Court. Now, let us decipher it point by point as to whether we should be blaming the High Court at all for that matter, or is there something else that is at play? So we'll be looking at that aspect in this video. Now, see, it is always important that when you take something out of context, when you take these three or two lines, two sentences, you take this one sentence, two lines, and you put it across, it becomes the context of that entire thing becomes very difficult. Now what is happening in today's time is we have social media reach and penetration so deep with and we are connected so very well with the world that anything that we post or we read, we tend to make a lot of judgments merely on the basis of certain headlines that we read. So we don't go into the depth of the understanding of the issue, and we make a particular judgment about the same without actually understanding the entire issue at play. And the idea with this video that I want to communicate is that let us, before jumping to the conclusion and before start blaming the High Court and saying that what kind of judicial setup that we have, what kind of judges are we, do we have that, how can they even think like this? Let us understand what actually happened. Again, the intention here is not to is not to downplay the role of the offense itself. The intention is to completely understand as to what has happened in this particular case. All right. Now, this particular case, the name of this case was Dilip, Pandey and others versus State of Chhattisgarh. Now, in this, if I read out, the exact paraphrasing of what the court has said in its judgment, it said that sexual intercourse or a sexual act by a man with his own wife, the wife not being under 18 years of age, is not rape. In this case, the complainant's legally wedded wife of applicant number 1, which is Dilip Pandey, therefore, sexually intercourse or any sexual act with her by Dilip Pandey, the husband, would not constitute an offense of rape, even if it was by force or against her will. All right. Now we need to understand what is the legal provision behind this. Now, if we refer to section 375 of Indian Penal Code, it gives the definition for rape. Now, this is one particular, offense that everyone should be very, very sensitive towards. And especially we need, and especially law also looks at this particular offense, or rather all the offenses against women, with a very strict hand against the accused. Now, there is an explanation 2 that is added in the Indian Penal Code. Now, what is that explanation 2? The explanation 2 that has been added to Indian Penal Code is that marital rape or any form of sexual intercourse, any form of sexual act in a marriage will not amount to an offense of rape. Now, this is an explanation that has been added to the Indian Penal Code. Now, who adds these explanations? Who makes these laws? It's pretty simple. The laws are being made by the parliament or the state legislative assemblies. It's the parliamentarians or our politicians who are making these laws. Now, let me give you a context going back a few years. In 2017, the actual provision of the Indian Penal Code for explanation 2 reads that under the age of 18 years is something which Supreme Court in 2017 in the case of Independent Thought versus Union of India had interpreted. Otherwise, in the law books, in under IPC, it is still 15 years. So basically, a sexual intercourse with a girl who is below the age of 15 years would amount to rape. But, but a wife who is above 15 and like above 15 years, that would not amount to rape. Now, that is the explanation which is there in the book, which is there in the Indian Penal Code. The job of the judiciary is to interpret the law. Making the laws is something which falls under the domain of the legislature, which is the parliament or the state legislative assemblies. Now, in this particular case in 2017, which is Independent Thought versus Union of India, Supreme Court applied its judicious mind and said that 15 years is not something which is agreeable to us, because for rest everything, be it for marriage, be it for getting electoral rights, for that matter entering into a contract, the cutoff age that has been kept is 18 years. So keeping 15 years as an age in the law makes no sense to us, and they said that it is going to be 18 years. Now, this is something, the effect of the law is that since Supreme Court has interpreted the law in a particular way, then that is something which is applicable for the whole of country. Now, what the parliament could have done is they could have brought in a simple amendment or a change in the Indian Penal Code, which did not happen. And still, if you look at the actual law, the Indian Penal Code book, you would still find 15 years there. But the actual effect is, no, it is not 15, it is 18. Now, this is the effect of the interpretation by the judiciary itself. Now, there are certain elements when, with respect to rape for that matter in our country, and it is something which is, the law of rape in India is something which needs a big time overhaul. Marital rape is no offense according to Indian Penal Code. Below 18 years, because of the interpretation of Supreme Court, below 18 years, sex with a wife, lawful wife, would still amount to an offense of rape. But otherwise, above 18, there is no concept of marital rape. Is this fair? Absolutely not. Should the law change? Yes. I completely agree. The law should change. Is 2021 the time that we should be talking about and should be holding our lawmakers, policymakers accountable for not understanding the gravity and sensitivity attached to this issue? I agree. We should hold them accountable. Second issue that also crops up is that rape in India is not a gender neutral law. So it is something, rape can happen only with a woman, right? And yes, I completely agree that after the Nirbhaya case, the law did change. A lot of things were, added, was made more sensitive, was made more exhaustive. I completely agree. But then again, it has been like 6-7 years. I know society has changed. We look at how people are behaving, and keeping all that in mind, I think yes, it requires a complete overhaul. We need to start thinking more like Western countries when it comes to offenses against women, especially in a country like India, where we see if we just look at the National Crime Record Bureau statistics that are released every year, we would see that gradually over the years, the crime against women has only increased, has not come down. In fact, after the amendment of the criminal law after Nirbhaya incidents, the number of rape cases in India had gone up and not down. So, do we really need to start thinking a little differently? I completely agree. There are a lot of issues around the offense of rape that needs a complete overhaul. The basic crux of the point is we cannot be making judiciary the scapegoat for everything that they do, or everything that they say, or everything that they hold. Reason being, judiciary is something which जिसका की फंक्शन जो है वो सिर्फ लॉ को इंटरप्रेट करना है. जुडिशरी बैठी हुई है लॉ को इंटरप्रेट करने के लिए. अब आप मेरे को लॉ ही बना के दोगे कि मैरिटल रेप ऑफेंस नहीं है, तो जजेस उसको ऑफेंस थोड़े बना देंगे. दे कैन नॉट डू दैट बिकॉज वो उनका पावर नहीं है, वो उनका रेल्म नहीं है. हाँ, अगर आप आईपीसी को चेंज कर देते हो, आप आईपीसी को, इंडियन पीनल कोड को आप अमेंड कर देते हो और उसके बाद आप बोलते हो कि मैरिटल रेप जो है वो ऑफेंस होगा, देन उसके बाद देखो कोई भी कोर्ट जो है वो इस तरीके का जजमेंट नहीं दे पाएगी, बिकॉज दे नो एंड दे विल बी इंटरप्रेटिंग द लॉ दैट इज द लॉ ऑफ द लैंड. वो इंडिया का लॉ है. सो आइडियली अगर इस पूरे इशू पे हमको बात करनी चाहिए, तो वी शुड बी होल्डिंग आवर लेजिस्लेचर और आवर लेजिस्लेटिव मेंबर्स अकाउंटेबल कि भाई क्यों नहीं है कि हम मैरिटल रेप एज अ ऑफेंस के बारे में बात कर सकते हैं. व्हाई इज इट दैट वी कैन नॉट इवन हैव अ डिस्कशन इन द पार्लियामेंट अबाउट इट? Let us at least have a discussion, because democratic setup का यही advantage होता है कि हम the parliamentarians are accountable to the people, right? The members of the लोक सभा हर 5 साल पे आपके पास आएंगे और वोट मांगेंगे कि भाई we want to be your representative. So they are directly accountable to us. Why do we not ask this question to our to our parliamentarians? One, I guess the society is not ready. Second, the biggest reason of all is I think we are not sensitive enough, we are not sensitized enough about the issue, and we don't understand the gravity of it. How can we do that? I think bringing in more knowledge, bringing in more awareness about what the ground reality is, I think that is something which is the pertinent issue of the time in 2021. We need to make people more aware about what is the situation that women live. And I completely agree that a lot of cases would not even be reported. So nobody actually knows the real picture and the big menace that this might actually be. Because ultimately, sexual intercourse sexual intercourse has to be consensual. There has to be consent. दोनों parties का consent होना बहुत important है. और decision making जो कि consent पे आप पहुंचोगे कैसे, जब मेरे पास deciding factor होगा, मेरे पास decision making power होगा. अगर आप मेरे को वो decision making power ही नहीं दोगे तो मेरा consent नहीं होगा, right? And हमको actually नहीं पता कि ground reality कितनी अलग हो सकती है. तो therefore I think it is important कि लॉ कमीशन ऑफ इंडिया इसके ऊपर एक बहुत एक्सटेंसिव स्टडी करे. लॉ कमीशन को बोला जाए कि इसके ऊपर आइडियाज़ निकाला जाए कि किस तरीके से लॉज को चेंज किया जा सकता है, एंड मे बी हैव अ डिस्कशन इन द पार्लियामेंट अबाउट द पॉसिबिलिटी कि इसको क्या हम रेप को जेंडर न्यूट्रल बना सकते हैं, क्या हम मैरिटल रेप को इंक्लूड कर सकते हैं अंडर सेक्शन 375. एटलीस्ट देयर शुड बी अ डिस्कशन. अच्छा, इसी पर्टिकुलर केस में कोर्ट ने सेक्शन 377 को भी इंटरप्रेट किया है. 377 एक्चुअली बात करता है अननेचुरल ऑफेंसेस के बारे में, राइट? अननेचुरल ऑफेंसेस जो है वो ऑर्डर ऑफ द नेचर के अगेंस्ट है. आप कोई भी अननेचुरल काम, सेक्सुअल एक्टिविटी नहीं कर सकते. सो कोर्ट ने इस when it came to interpreting his behavior with respect to repeatedly inserting objects in the sexual organ of the wife and consequently deriving sexual pleasures out of such act, the court said that this constitutes carnal intercourse against the order of the nature and therefore under section 377 the husband would definitely be liable. We will make him accountable, we'll hold him accountable for an offense under section 377 because inserting objects into the sexual organs of any person is against the order of the nature. You cannot do that, and though it does not amount to an offense of rape because 377 is a different section altogether. Now 377 was also used at the time to criminalize sexual intercourse between a man and a man or a woman and a woman, like basically gay or lesbian relationship. But that is something which Supreme Court also interpreted and said, the time has come that we should be done, we should be doing away with it. And so for that particular part, with respect to same-sex intercourse, Supreme Court said Section 377 to be unconstitutional. But for the remainder of the part, the Supreme Court said Section 377 to be very valid in the eyes of law. So all of this that we see, the progression in the law that we see happening is actually from the side of the judiciary itself. It is not from the side of the legislature. Parliament की तरफ से कोई movement नहीं है. Parliament is not doing कि we should be thinking about decriminalizing certain acts or criminalizing certain acts. जितना भी sensitization हो रहा है वो judiciary के through हो रहा है. But again, what happens is in cases like this जहाँ पे हमको एक headline मिल जाती है, हम उसके बाद फिर शुरू हो जाते हैं कि नहीं ये तो judiciary जो है वो सही नहीं है, इनका interpretation कैसा है, बहुत weird है, these people are not sensitive enough. But I hope this video would have made more clarity to you कि how that is not the correct picture. So that is all that I had to offer about this whole controversy. Let me very quickly run you through the features that Unacademy has to offer, which is India's largest learning platform, online platform, where you get to interact with the best educators who themselves have graduated from national law universities. You get access to national mock tests, sexual tests, and you can attend these classes anytime and anywhere. There are multiple batches जिसका कि आप सब्सक्रिप्शन लेके अपनी पढ़ाई शुरू कर सकते हो, आप सीख सकते हो और अपनी प्रिपरेशन को किक स्टार्ट कर सकते हो फॉर लॉ एंट्रेंस एग्जामिनेशन 2022 or maybe law entrance examination 2023. And when you decide to go for a subscription, what you can do is to get an additional 10% discount on your subscription fee. You can use my referral discount, which is BAI10, and get a 10% discount. And your subscription can start from 1 month and can go up to 2 years. You have live quiz features जहाँ पे कि आप अपने फ्रेंड्स के साथ इंटरैक्ट कर सकते हो, सेल्फ स्टडी कर सकते हो, या फिर आप एजुकेटर्स के साथ कर सकते हो. And in case you find anything inappropriate being delivered in the lecture or video, you can use the form in the description of this video to raise that issue. You also get free tests every week from Monday to Friday for your own practice, but when you take a subscription, you get enough practice material to be aware. We also have free special classes at Unacademy platform जो कि free होती है और आप उसको भी आके attend कर सकते हो. What you can do is follow me on Unacademy portal. उस मेरे Unacademy प्रोफाइल लिंक जो है इस वीडियो के डिस्क्रिप्शन में दिया हुआ है, और मैं जब भी कोई फ्री स्पेशल क्लास शेड्यूल करूँगा तो आपको नोटिफिकेशन मिल जाएगा. द ओनली थिंग दैट यू नीड टू डू इज मेक अ स्टूडेंट प्रोफाइल ऑन Unacademy पोर्टल. तो वंस यू आर डन विद दैट, आपको मेरे नोटिफिकेशंस मिल जाएंगे और आप मेरी क्लास आके फ्री में अटेंड कर सकते हो. Also, don't forget to subscribe to Unacademy Law for more such content, more such videos. हम कई सारी बातें करते रहते हैं, हम कई सारे लॉज पढ़ते रहते हैं, तो आप आके उसको YouTube पे पढ़ सकते हो, देख सकते हो, आप कभी भी अटेंड कर सकते हो उन क्लासेस को. अगर आप छूट भी गया तो you can watch it at a later point in time also. And also, if you really like the video, please don't forget to like, share and comment upon the video. Also, what you can do is join Unacademy Law Telegram channel, जहाँ पे कि कई सारे educators, not just me, but many educators keep posting their class links and class schedules, जो कि freely available होती है, तो आप वो classes भी attend कर सकते हो. On this note, I would really like to thank all of you for going through this video. I really hope that you got a better insight, better perspective with respect to the whole issue that has embroiled in a controversy over the social media. Let's stay responsible, let's read, let's continue reading, and we'll meet again for another video, for another session Till then, thank you so much. Take care. Bye bye.